after midnight, you're sitting in a car at a hotel. What are they doing running up and down other than getting drugs because you've got a meth pipe that you throw out as soon as the cops get there? Being out at midnight with buddies running up to a hotel with meth. So, nope. Mr. Culie is on probation for obstruction or retaliation. And Mr. Macon has asked for a bond to be set. Let me look real quick here. I say real quick.
Yeah, I brought it down. I have a note on it.
Sorry, it's just taking a little bit. It's spinning. All right, so it's a straight probation. It was a 10-year probation that was probated for 10 years. And the allegations in that motion are an allegation of a new offense of tampering with or fabricating physical evidence from August 9th. And then failure to report by mail some dates, failure to report change of address, failing to report that arrest, possessing methamphetamine August 9th of 2025, failing to provide verification of performing community service, being somewhere other than at his residence at 12:12 a.m. on August 9th of 2025, and then just a little bit behind in court-assessed fees. Let me see here. Looks like Mr. Culie has previously been to SAFPF as a condition of probation back in 2023. This is at least the, so he was on a deferred probation, revoked off of that probation, placed on a straight probation. So this is at least the third, it looks like, motion to revoke. Is that correct? Okay. Give me, I'm trying to get back all the way, if I can find the old pre-sentence report, just to refresh, but I don't see that.
I have a copy if you look at it.
I would love to look at a copy of that. If you have it, that'd be great. And while you're doing that, what is the status of the new alleged offense of that tampering?
It has not been filed, Your Honor.
It hasn't been filed yet.
Any idea what's...
Actually, probably will, but I can confirm that.
I can't hear you.
I expect it would probably be filed, but I need to confirm that.
Mr. Macon, you may proceed.
Yes, Your Honor. I'd call Mr. Cooley, Your Honor.
Mr. Cooley, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you, sir.
Mr. Cooley, your probation was transferred to Dallas, correct?
Yes, sir.
And have you, how many times have you reported in Dallas?
I'm not sure the exact number, but since I've been home for safety, for safety maybe 2 years now. So every time since then.
Monthly?
Monthly.
Okay. And during that time, did they give you your drug screening, drug test?
Yes, sir.
And did you pass all of them?
All of them.
Okay. Now, the judge has mentioned this new arrest and all. Were you in a car with other people?
Yes, sir.
Did you know they had paraphernalia and drugs in the car?
I did.
You did?
I did.
Okay, you understand you can't even be around people like that.
So I didn't realize that they had it till the last minute. It was black judgment, straight up black judgment.
Okay. But you weren't doing drugs?
No.
Okay. Why did you mail reporting things to Jefferson County?
So coming from Jefferson County and then being transferred to Dallas, it's worked. Coming home from SAFPF, there's a lot of different, I guess you say a lot of different things that you're trying to keep up with. Every month when I meet the PO, they go down a list of things. Are you paying your fines? Are you keeping up with community service? Are you doing this? Are you doing that? Are you doing that? That wasn't on the list of things to do.
And you didn't think you needed to mail something to Jefferson
No,
County?
not at all.
Okay, but you reported all the time to Dallas?
I didn't miss anything.
And did everything you were supposed to in Dallas?
Correct.
Okay, who was your Dallas probation
So
officer?
I've had numerous. They switch them. I probably had, since I've been home from safety, I probably had 3 or 4 different probation officers.
Okay. Now, should the judge grant you a bond, will you report and be here for every court appearance?
100%.
Okay, while we're on that, you turned yourself in, correct? As soon as you found out there was a warrant for your arrest.
I did. So I'm, Ms. West, and in all honesty, Judge West, I'm thankful for you. I'm truly thankful for you. That safety, it completely saved my life.
Okay. Now, should you make bond, you have jobs waiting for you, right?
I do.
Okay, in fact, you have 2 jobs.
Yes, sir.
Okay, so you're always staying busy and paying everything.
I am.
Okay. Your wife lives up in Dallas, and you would naturally ask that you be allowed to go back to Dallas, but report by mail to Jefferson County. You understand that now? Yes.
Yes, sir.
Okay.
Okay, so just for the record, I'm reviewing the administrative hearing, which has attached to it that incident report from the Dallas arrest. And I'm a little confused because the incident report narrative states that Mr. Culie was the only occupant in the car.
Go.
Ma'am?
Mhm.
So I was the only occupant in the car at the time. I was sitting at a hotel. I had 3 to 4 people with me. They ran upstairs to the hotel to come back down. So they were literally.
So what?
I offered the officer.
Hold on.
Yes, ma'am.
Okay, and that's fine if you were doing that. It's after midnight. You're sitting in a car at a hotel. What are they doing running up and down other than getting drugs because you've got a meth pipe that you throw out as soon as the cops get there?
This is where Mr. Culie's bond argument begins to collapse. His attorney initially framed the arrest as a case of unknowingly riding with people who possessed drugs, but the incident report says he was the only person inside the vehicle when police arrived. His clarification that several companions had temporarily gone into the hotel does not necessarily disprove his account, but it introduces details only after Judge West identifies the inconsistency. Did you notice how quickly a favorable wrong crowd narrative became a credibility problem? Judge West is not deciding the final tampering or drug allegations at this hearing, particularly because the new offense has not yet been filed. She is assessing whether releasing him would create an unacceptable risk while the revocation remains pending. The reported disposal of a meth pipe, the after-midnight location, and his history of repeated probation interventions all weigh heavily against him. Turning himself in, maintaining employment, and claiming successful drug screens help the defense, but bond decisions are predictive. The question is not merely whether he will appear, it is whether his recent conduct suggests that another opportunity at release can be safely trusted.
And Mr. Smith, anything to add?
Well, not as far as that goes, Judge, but I was going to show you the pre-sentence update that shows that he was aware of reporting by mail because it was addressed in 2022 or 2023 when that came up.
Your request for a bond's denied. I mean, this has been probation since, well, I guess when did we actually start? Back in 16 or even
Before I
before?
was here, Rachel Grove was the prosecutor.
Yeah. And it's gone from the opportunity of a deferred to now a straight to
With
safety to being out at midnight with buddies running up to a hotel with meth. So, nope. I'll set it for an announcement for the
Thank you.
NTRP.
We'd like a hearing as soon as possible.
Do you want to go ahead and go through the motion today then? Because you'll have to go through and plead true or not true, and then if you want a hearing on punishment, we'll reset it for that. So if you want to go ahead and do the pleas today, y'all can visit real quick.
Could I have a week, Your Honor, to go over my client and be ready for that?
Yeah, it'll just be for the pleas though, not a hearing.
Yeah.
Okay, unless it's, because we'll have to get an update and all of that. So we'll reset it. I don't know what
Whenever
next week
council
looks like.
can.
We don't have next week because it's a holiday. Tuesday is, so it'll be a couple of weeks.
Oh, Thanksgiving.
No,
Oh, it's
next week is
Oh, yeah.
Veterans
Y'all
Day.
observe that too?
So it'll be at least 2 weeks, and that'll be just for a plea.
That'll be
Just for the
fine.
pleas. Okay, we'll reset it.
Yeah.
All right, you can go back with the bailiff. All right. And so I have a motion to revoke your community supervision. Shows that you were placed on probation September 9th of 2024 for the third-degree felony offense of unlawful possession of a firearm by a felon. That was a 10-year sentence that was probated for 5 years. Is that correct? It alleges you violated your probation. Hold on a second. I'm printing it out. I'm having a hard time reading it. Count 1 alleges that you committed the new offense of possession of a controlled substance July 4th of 2025. And is that true or not true?
Speak up. Not true.
Count 2 alleges that you failed to avoid persons or places of disreputable or harmful character, specifically avoiding association with any person previously convicted of a crime or presence at a location where a criminal act was being committed by associating with Xavier Kane, who is also on felony probation. And is that true or not true?
Not true.
Count 3 alleges that you failed to report to the probation department as ordered July 8th and July 29th of 2025. And is that true or not true?
True.
Count 4 alleges that you failed to immediately report to the probation officer that arrest from July 4th of 2025. Is that true or not true?
True.
Count 5 alleges that you possessed a drug on July 4th, 2025, promethazine and tetrahydrocannabinol, THC. Is that true or not true?
Not true.
Count 6 alleges that you admitted to admitted to the sheriff's office to using illegal drugs, THC, on July 4th of 2025. Is that true or not true?
Not true.
Count 7 alleges that you failed to provide verification of performing the community service hours as directed. Is that true or not true?
Not true.
And count 8 alleges that you were at a location other than your residence at 12:44 a.m. on July 4th, 2025. And is that true or not true?
That's true.
Did you enter your pleas of true to counts 3, 4, and 8 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
All right, then I'm going to find counts 3, 4, and 8 true, find sufficient evidence to revoke your probation. However, I'm going to reset your case for a sentencing hearing. And
This is the decisive procedural turning point in the second case. By pleading true to failing to report, failing to disclose the arrest, and being away from his residence after midnight, the defendant gives Judge West an independent legal basis to revoke probation without first resolving the contested drug possession allegations. A revocation does not require every alleged violation to be proven. One sufficiently established violation can be enough, and here the court has accepted 3 voluntary admissions. The defense preserves not true pleas to the controlled substance, association, drug use, and community service allegations. That strategy prevents those accusations from becoming admitted facts, but it does not erase their possible importance at sentencing. Judge West wants an updated presentence report and additional information concerning the new offense before deciding punishment. That signals she is separating 2 questions: whether probation was violated and what consequences justified. Would immediate sentencing actually help this defendant? Probably not without a complete record. His employment and apparent payment history provide mitigation, but his prior revoked felony probations, robbery and theft of a firearm, make another release request difficult. Judge West is now evaluating whether community supervision still has rehabilitative value or whether the repeated pattern demands confinement.
And at that time, Mr. Nichols, I would expect the state will need some time for that new offense.
Yes, Your Honor.
And my understanding is, I know there's some issues with some backlog, but if you request, I think they'll try to get the case for us done quickly. If you need my help, let me know. And then we'll get an updated pre-sentence report done. And so this is a straight probation for felon in possession of a firearm, which means there's at least...
He has two prior felony probations that were both revoked together, Your Honor. One is robbery, one is theft of a firearm.
Do you have any evidence with regard to that, Mr. Bond, Mr. Kimler?
Come on.
As far as the details of the previous convictions or
No,
his
just,
status.
do you want to make argument? Do you have any
Well, I think
witnesses, any testimony with regard to that?
I understand it is adjudicated probation and not deferred. However, Mr. Phillips has, I think, maintained employment. I noticed that there isn't any allegation in the MTOP as far as an arrearage goes. At least he's been paying, I guess. This was evidently an unfortunate interaction with law enforcement that occurred. We are contesting possession issues, so we just ask that he be given an opportunity to maintain his employment pending a resolution of the MTOP.
That's denied.
No, it's just that I did file a motion for a speedy revocation hearing.
We pled today. We'll get it set for the hearing as quickly as possible. Obviously, we've got to have that updated pre-sentence report, and everyone has time to but it's already well on its way with the pleas today.
I think that according to the code, it has to be within 20 days of the request if the bond's denied. That's contained in the motion.
We started the hearing today, and I'm continuing that hearing until the appropriate time. So we set it for, you requested it. It was set within 20 days. The hearing would start today, and if you want me to go forward today, that probably would not be in anyone's best interest. I will get the updated pre-sentence report, give everyone time, and then we'll get it taken care of and continue this hearing until the sentencing date is set, and we'll get that date to you today. You can go back with the bailiff.
Thank you, Your Honor.
Across these two probation matters, Judge West consistently focuses on demonstrated conduct rather than promises. In Mr. Culie's hearing, the defense emphasized employment, voluntary surrender, successful drug testing, and regular reporting in Dallas. But those favorable points were overwhelmed by his lengthy supervision history, prior treatment through SAF repeated revocation proceedings, and the police narrative placing him alone in a vehicle after midnight when a meth pipe was allegedly discarded. Most damaging was the tension between that report and his initial description of being in a car with other people. The judge did not need to determine guilt on the unfiled offense to conclude that bond was too risky. The second defendant's position became even more serious because he formally pleaded true to 3 violations. Those admissions supplied sufficient grounds for revocation, leaving punishment as the unresolved issue. Judge West denied bond but postponed sentencing, so the court could obtain an updated pre-sentence report and information about the contested new offense. That protects the quality of the sentencing decision, even if it keeps the defendant in custody longer. The defense raised the statutory timing request, but Judge West answered that the hearing had commenced within the requested period and was being continued. Forcing the punishment phase forward immediately, without updated records or adequate preparation, could have harmed both sides. Do you think counsel was protecting the defendant's speedy hearing rights or applying pressure for a faster release opportunity? The broader lesson is that probation is an alternative to incarceration conditioned on strict compliance. Employment helps, but it rarely neutralizes repeated violations, damaging admissions, or credibility concerns. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.